didn't even read the bill. It was a big bill. It was 300 and something pages, and there wasn't floor debate really. It was something that people really just said, okay, we're just going to pass this because if we don't, and something else happens, we're going to be in deep doo-doo.
Yeah, I wouldn't say purely political reasons. I think certainly Daschle's spinelessness on that had an important political component to it. But I think the folks at the White House were sincere in that, their view, in my view correctly, was we're at war and they wanted to say, they trusted themselves, and so therefore give the executive branch all possible powers. And so they weren't particularly interested in something that would say, well, I understand your base. You need this much, but you're getting this, and can't we fix the language and improve it? And their view was, well, if we had infinite powers, we wouldn't misuse them. And even some of us folks who said, well, maybe, these guys would do okay. What happens when Hillary Clinton becomes president or somebody else? Because these powers may stick around for a long time.
And they probably will.
And it seems like the majority of the document is just kind of editing or rephrasing a lot of phrases in Title 18 of the U.S. Code and other various aspects of the code. So it's not like there are brand new laws or stipulations or restrictions in there so much as there was a lot of redefining and renaming. Is that a correct assessment?
Yeah, I think there was a lot of amending of existing statutes, but certainly amending it in a way that dramatically changed the powers and oversight of the FBI, of the executive branch generally, of DOJ. It really went way too far. But there was some new stuff in it, but a lot of it was amending existing statutes.
Let me give you just one example on that. Normally when you get searched, and that's part of the checks and balances of the Fourth Amendment, which prohibits warrantless searches and unreasonable searches. And so if somebody comes into your home and looks around, you'll know about it. Often they'll bust the home up, so you'll certainly know about it. And so if something was done wrong, then you can pursue your remedies, maybe through a civil suit in the most extreme case, or even through just speaking out in public. In a lesser case, and the press might take interest. But if you're searched secretly, then we lose that key part of the checks and balances for knowing whether making sure that searches stay within constitutional bounds. There's a particular type of search that's called informally called sneak and peek, which is, say, the police go into somebody's home, look around when he's not there, maybe put in a surveillance device, and then leave, and the person never knows he's been searched. That had already been something you could authorize under extraordinary circumstances where you showed the judge or magistrate there was a real particularized need for it. The Patriot Act greatly expanded the sneak and peek powers without the strong need to get the backing from the judge or magistrate based on particular conditions. And you could make, I think, at least an argument that, well, in a terrorism investigation, maybe we want to be just doing this all the time, sneaking and peeking in on the suspected Al-Qaeda sleepers and all those folks. But sneak and peek was expanded to everything. So if they're investigating you for cheating on your student loans, illegal interstate gambling, marijuana cultivation, pornography or anything else, putting aside whether those are properly federal crimes at all, or burglary or whatever, things that were not suddenly obvious extraordinary risks after September 11, the sneak and peek powers applied to that too. If they'd actually just limited the Patriot Act to terrorism, there would have been a lot fewer objections to it from many civil libertarians. But it has been used for gambling offenses, which I think is atrocious.
Yeah, as a matter of fact, with sneak and peeks, normally you would get a subpoena or a warrant before anybody took your records, for example, if they wanted your business records. In Section 215, they were granted the power to ask for these records, and then they instituted a gag rule, so that if they went to your bank and asked for your banking records, ordinarily they would do that with a subpoena. The bank would notify you. You would have an opportunity to go to court and say, Your Honor, please make them prove that they need my banking records. Or in exigent circumstances, they could do it on an emergency basis. But normally speaking, you would have an opportunity to challenge the subpoena. However, in the Patriot Act, in Section 215, what would happen is they would go to the bank or to your doctor or to your school or to any place that might have something of yours, some tangible thing, a record, those kinds of things. This was also it was also known as the Library Act, although that has been changed. But nonetheless, they could go and get those records, and you'd never know it, because they were not allowed, the bank or the doctor, they were not allowed to tell you that the government had asked for your records. So they would get your records, and they could go through it for any reason. It did not have to be for terrorism. And the whole probable cause requirement was much less with this kind of thing. And so with the Patriot Act 215 order, and so what you ended up having is you could have broadcast record accumulation of yours, and it could tell them a lot about you, and it didn't necessarily have to do with terrorism. I mean, it was just something they could do. And actually, Newt Gingrich, in an article in the San Francisco Chronicle, indicated that he thought that this had gone too far. That if they wanted to give law enforcement that kind of open access to your tangible things, then they should do that. But they shouldn't do it through the Patriot Act. And actually, the sneak and peek was used against Brian Mayfield, who the FBI arrested for the Madrid bombings. They had found something in a sneak and peek in his home that led them to charge him as part of the Madrid subway bombers. What ended up happening with that was that he had converted to Islam, and they suspected him because he was, of course, active in his mosque. So when the Spanish government looked at their evidence, the Spanish government said, this is not the guy. This has nothing to do with the Madrid subway bombings. He was not involved with it. Hey, folks at the FBI, he didn't do it. And finally, after quite some time, the FBI relented and dropped the charges against Mr. Mayfield. But everything they accumulated in sneak and peek and in secret document subpoenas.
Well, and this is an example of how there is something in the Patriot Act which I think is good, but it goes too far. And for those of you who are not law students or lawyers, a warrant is something that a judge issues, authorizing a search. A subpoena is something that an agency writes for itself. So an FBI agent could write his own subpoena or go to an FBI lawyer and have it done. And there's no checks and balances in the issuance of a subpoena, except to the extent that the agency sort of voluntarily imposes good standards on itself, which the FBI often does, but sometimes does not, and that's true for federal law enforcement in general. And it is also true that there are a lot of judges and magistrates who are pretty lackadaisical in reviewing warrant applications, but some are not, and even the process of just having to do the warrant application serves as a check and balance. That you got to put it down to, you got to justify it to somebody outside your agency. So I think there's a very strong rationale to say when you're doing a terrorism investigation for some guy you think might be part of a sleeper cell, you don't want to know, you don't want him to know that he's under investigation because then maybe he'll leave the country, or maybe he'll stop doing whatever he's doing, and maybe he's low on the food chain, and you want to find out who his contacts and handlers are higher up.